So this sheet that I put together I put this sheet together for quite a few months now, is actually even more significant and even more important than I thought for our channels, for our YouTube channels and Facebook and everywhere that we are publishing, sharing the petition or promoting the petition. And this actually is significant to Robert F. Kennedy Jr., really, with his case against YouTube on the American side of it as well, once you understand this model and how it works. And this definitely works this way. It's definitely correct. And I think it's just a shame that I think the Parliament MPs, they're either a bit unintelligent or they're being misled, or the staff of Parliament aren't that intelligent. Now, I know a lot of them are really interested in politics and like politics, and they go to the National Archives, and but I do think that they are they've not seen this, or if they have, they just haven't cared. But it's critically important. Now, it's primarily going to be this Town and Country Planning Act 2007, right? This Class F, just this short, paragraph, a couple of sentences. It's only about, 20, 30 words. So in this Class F, these words now, an advertisement required to be displayed by standing orders of either House of Parliament or by any enactment or any condition imposed by any enactment or on the exercise of any function. Obviously, functions that are in connection with the aforementioned. Functions of law, basically, because that's what enactments do. It's the law. You've got to follow the law. Now, this Class F is in the Town and Country Planning Act 2007 statutory instruments, right? And that act it's whenever when you're advertising something, right? Or sharing anything, printed matter, but it also says, I'll tell you what, it covers digital devices as well. So you might think the word advertisements means commercial, but you can have advertisements for politics, for political things, right? Or elections or referendums, voting, right? Promoting things. Even when you publish something to post it through someone's letterbox, like poll cards or petition addresses, election addresses, referendum addresses. Now, this is the thing. This is an act of law, right? This is an act of law, right? And what's it used for? Well, it's used for making copies of and displaying political material to the public or any that uses an enactment of law, right? Also, criminal investigation uses the Criminal Law Act. It uses this act, but also the Criminal Law Act 1967 makes it an offence for anyone to obstruct you while you're pursuing criminals, investigating, because they're obstructing your investigation. So if the newspaper was to, the newspaper can't obstruct an investigation. This is where we get onto this really is the First Amendment of America, the right to petition and the use of free speech for that and the right to publish for that. Otherwise, you can't do it. You can't make it available to the public. It does include private newspapers and companies because they're there for stories and adverts and publications. But the thing is, commercial ones, you got trading standards and consumer rights anyway. But the thing is, with these other functions, like, an investigation, you've got the law backing you up, right? And you're using the right to petition. That it is the 1688 Bill of Rights that gives you the right to do it, to make copies. So if you're making a copy to give to multiple people or to put on a wall to notify them, the right to copy is make another copy, right? So you're making it available to another person or other people, right? And it's in any form, in whatever form and through whatever means, it says here, right? This is the definition of publish. I've got this from the local government England for referendums regulations, but this is, I can guarantee you, this is the definition of publish for petitions and referendums as well, not just elections. This is what it means: to make available to the public or a section of the public at large in whatever form and by whatever means, because that is exercising a function, and you're exercising a function with use of legislation, which is the 1688 Bill, or you can use certain, there are various laws in criminal procedures or civil procedures as well, Now, the thing is, you've got the right to do it through the Act, but people might not comply with you. People might try obstruct you or object, right? But this is why the police might be obstructed when they're exercising a function, or if you've got a civil case, you might be obstructed in pursuing that. When we're doing any form of legal proceedings, of which elections, petitions, and referendums are legal proceedings, if people aren't complying with normal requests or normal, if people won't comply when the law says you have a legal right, then you have to get the court to exercise its jurisdiction to enforce or back you up, right? And this is in civil and criminal cases. It doesn't really matter whether it's civil or criminal, because, what you do is, if you've got a right to some information or a right to access information, or, you want to speak to someone to question them or whatsoever, you want to have them as a witness, you require them, then, you have to get the court to use its powers. That's why it has powers, not just to make orders, but to facilitate proceedings and actions. So you ask for subpoena, you submit directions to the court if you fill the form in properly, or to summon people for witnesses, or for a warrant to get something from somewhere, to search it for something, right? Now, the thing is, when you're doing a petition case, it's legal proceedings. It is legal proceedings, but with Parliament, right? You used to, from 1661, you actually had, you had a judge, or a judge and jury, or you had magistrates, London magistrates. But they removed them from it because you've got the Petitions Committee, right? Now, the Petitions Committee is operating like a very small, it's a small jurisdictive operation for casework with government, but it doesn't make criminal orders or usually, order people, like fine people or anything like that, although councils do. Council chambers issue fines, and that's where they've got justice of the peace powers, or used to have, but they get the courts to do it now or refer it to a court. See these little jurisdictions, inquiries or tribunal, they can refer matters to courts to get things actioned. You see, this is what, Parliament are doing, referring matters also to like, the army, for taking things down from YouTube. Now, this is the thing, right? So, standing orders. An advertisement required to be displayed by standing orders of either of House of Parliament, right? So, well, when you're petitioning Parliament, you're using the right to petition, and that is in white here. This is the enactment we're using. This is the law that gives us the power. And the thing is, so this is the Parliament petition site. It's giving you a direction, right? The government Parliament petition site is telling you what to do, and it's publishing directions of telling you what to do, right? But these directions are backed up in law. They're backed up in law. They publish them to you and tell you to do something, but what are you doing? You're doing a legal case, right? It's backed up in law. Share on Facebook, email, and by Twitter. So this is legally supported because it's exercising a function of that petitions committee. When you run cases with that committee, you're sharing them on Facebook, email, and Twitter. They're private platforms, right? But it's not limited to those platforms because you've got the right, publish. You've got to publish it, share it by publishing it, making it available to the public at large or a section of the public in whatever form and by whatever means, right? When you share it, you're advertising it because you're making it available. Now, the definitions, Class F advertisement. So the definition is advertisement means word, letter, model, sign, placard, board, notice, awning, blind, device, or representation, whether illuminated or not, in the nature of employed, wholly or partly. Wholly or partly. Well, this is for your stickers coming here. Your stickers coming if you want to print up stickers to advertise the campaign, because you can print up a handbill like that you can give to someone to ask them to vote or to sign. But if you wanted it to be partly a sticker, because you wanted to stick it to the wall as a notice, because then it saves you going to get string or sellotape or drawing pins, it partly or wholly. So, that also falls into tax exemption as well, because your handbills are 0 rated, small advertisements are 0 rated, stickers aren't, but when it's a sticker that's a handbill and an advertisement, it is becoming 0 rated. But notice it says a representation, because you're making a representation. This word here in this act is where I'm using quite a difficult and complicated argument for what Extinction Rebellion or Stop ULEZ are doing when they are making advertisements, when they're going to film something to make an advertisement, a promotion for ULEZ, and using whatever they need to make that advertisement, or at least share it and publish it. It could be they're making representation and sharing it to the public, like making a little production, this is your definition. Legal representation can be an advertisement, right? Which you need that for witness appeals, or as well as just referendums, elections, and petition. Now, the thing is, right, so we are using the law, because this is the law that is used for doing petitions, but the petitions committee as well, right? And now what happens if someone doesn't comply with you? What happens if someone refuses, right, what happens if someone refuses to let you to publish it or let you share it? Well, the thing is, these sites are declared by the Petitions Committee to be used. You're given directions to use them by the Petitions Committee. Now, that Petitions Committee of Parliament is giving you that direction through powers of Parliament. Parliament is a jurisdictive authority. If it wasn't, it couldn't do anything. How does it even enact the law? Right? Now, we know what the Petitions Committee operates through the right to petition, but it also has these standing orders 145A. Right? So it's got powers. The standing orders are powers it's been given, or else it can't do anything. Like a tribunal or an inquiry has powers, right? And that's how it enforces everything that it does. If it can't enforce everything it does, there's no point it being Parliament. It's not the government, is it? Now, when it's like a court not having powers, why would you go to a court if it didn't have powers? If you had a civil claim and someone owed you money, why would you go to a court and have a case if it wasn't going to be able to make them pay the money? Or compel them to give evidence to prove that they owe you the money? Or summon witnesses to give statements to prove that you owed the money? It would be pointless. It wouldn't be a very good court. There would be no point in it, right? Now, it's the exact same with Parliament Petitions Committee. Now, so an advertisement required. Is actually required, not just an advertisement that can be or should be or may be. It's required through this Act, and not only through Standing Orders 145A. Required through this Act. This Act makes it by the Town and Country Planning Act required to be displayed. Now, your Standing Orders 145A has powers to compel, right? So, if you've got a standing order, right, first of all, we're using the enactment anyway, which gives us the right. This is the right to petition. Now, if people aren't complying with us, then we have to ask for the court to exercise its powers, or the tribunal or the inquiry to exercise its powers, because we have a right, because it's for a purpose. If you're investigating something or questioning a witness, you've got the right to ask or question them. Now, but you can ask for powers, because depending on what the function requires to be, you're required to find witnesses or you're required to summon witnesses. Now, part of summoning witnesses, you can't summon a witness if you can't contact them. If you can't contact a witness, you can't summon them, right? So how do you contact them if you don't know who they are? Well, you've got to air a message. You've got to place a notice, air a message, publish a message, share a message, place a message, say, hello witnesses, are you there? Can you come forward, right? So, this is the same with court. If you know who your witness is, right, or if you get a professor or you know someone, then if you ask them, you've got the right to ask them, they might appear. But if you really need them and, you need to compel someone to appear, then you have to ask the court to summon them, right? This is where the powers of court come in, or whatever jurisdiction authority it is. So the Petitions Committee have 145A and 3, 145A3 is the powers of summons to compel people. But if you can't make available the summons, if you can't make the summons available to those persons, but in any form, if you can't make it available to the witnesses in any form or by any means, you can't contact them, right? So the Petitions Committee have got 145A. They can summon people, and, you know, they can't be obstructed in the pursuit of that because they're in pursuit of proceedings in law, legal proceedings, like in the Criminal Law Act when you're in the pursuit of criminals, right? So if the, you know, we know that petitions, we're running them in connection with the Petitions Committee and through the committee, but also we've got to share them to people, not all in person, but digitally, because the Petitions Committee tells you to share them digitally. And it says digital form here. Advertisement includes digital form and means for the representation as well, which is this. This is what it is. This is it. This is a digital advertisement to share it, make it available by publishing it here to Facebook, email, Twitter. They're examples, right? They're examples. They're private. That means that YouTube can be used as well. Now, if Facebook, email, and Twitter are refusing or object, then they do not act. They refuse when you use your right to petition powers. Then you've got to ask the committee to exercise 145A powers, standing order powers, because you need to you need to contact the witnesses. You're contacting the witnesses by sharing the advertisement, right? So this is how you do it. And this is another law that you're using in conjunction with that. So if the Petitions Committee say that, you know, they don't know any acts of law that they use or that are used, they're lying or they're stupid. Because this very website that they've created a website. It's called parliament.gov.org.uk. The government owns the server, the website, right? Well, it's taxpayer paid for, right? The server is a device. The server of the Parliament's Petitions Committee is a device itself, like YouTube and Facebook. And it shares to us here not only the petitions, but directions and links to other sites to use in connection with this casework. So if some anonymous hackers or whatever removed this information or link from the Petitions Committee website, they would need to put it back up again, wouldn't they? Right? They don't take this down because we need access to it, right? So, we're officially given directions by Parliament, but the directions are, you can't follow directions or exercise directions or use directions if they're not backed up with legal powers, like I said right at the start. It won't be the point going to a court if they don't have any powers. You're bringing a case for a claim, and then, you know, if they don't have any powers, there's no point going there. Well, it's pointless. No. But also not just the end of the case when they make a final order. To get there, to get the material and the information and people, you're using the powers of that's why you're bringing proceedings to a court, because you need some, there's no point. So if we couldn't share or make our petitions available to people, to obtain the evidence, and the signatures, it would be you couldn't do it. It would be pointless, and it would be like going to a court that had no powers. So what are the powers for with the petitions? To share the petitions and collect signatures, and also if you get what is required for the Parliament to make whatever, you can do it. Now the debate or the inquiry or whatever. Now, so these are the stand. And the petition is an advertisement which is required to be displayed by Standing Orders 145A3 of the Petitions Committee of the House of Parliament to exercise the function, because that is why it's telling you to share it here, or else that is what it is. It's not only that is the law. The Town and Country Planning Act, that is the law which is giving you it's giving you legal directions of what to do and telling you what powers to use, an enactment. And the Petitions Committee is the authority, the jurisdiction of which you're doing it through, not the Civil Court, the Crown Court. So when you if you can use YouTube, Facebook and Twitter for petition promotion and adverts, and your what powers, well, you shouldn't need, if YouTube aren't complying with you or they remove your channel when it's supported by legal enforcement, you're already using the law, because you're using the right to petition, right? And if YouTube or Facebook or Twitter or X, whatever you want to call it, or Instagram or Outlook, whatever, refuse to comply, then you've got to say to the Petitions Committee, they've removed my petition. I can't share my petition on Facebook, email or Twitter. It's been removed. You need to put it back up, right? So you need to say to the Petitions Committee, I need, I want, I need to subpoena my advertisement back, or subpoena his access to information. Well, you can't access it if they blocked your account. There are two things going on. Firstly, if it's been shared or published or made available to the public or made available to you. Now, a subpoena is to make information available to you, not necessarily the public. But for the Petitions Committee, it's not just you accessing your own information, but the public as well, So it's a little bit different because with the petition, it's a little bit slightly different setup to criminal and civil, because the jury is. You go the jury. You're bringing the case with the jury to the ministers. Now, the thing is, the Petitions Committee are just like pretending they're stupid and going, "Oh, we don't know what you're talking about," or "We can't do this, we can't do that." Just lying, lie, or. Stupid. One, either or, right? Either or. So we need to find out whether they haven't got the training, whether they've been mistrained, whether they are acting with a unvoiced political agenda of a political party like the Labour Party or the Conservative Party, and obstructing us from our public function service of the committee's services are being hijacked or abused for a political party agenda, which, it would be like the public toilets being locked and they don't let women use them. If the public toilets were unisex, but then the council wouldn't let any men in or wouldn't let any women in, like that kind of thing, but they're meant to be there for everyone, right? So they can everyone can take a pee when they need to go, so they don't pee on the street and get arrested, right? So this is the thing. So now, if the petitions committee are, you've got to ask, but if you've got reason, the thing is, they can't. They've got a very difficult. I mean, if you want something ridiculous, like I want all the files or information from the chemical factory to prove that they're polluting the environment, so I can put on my petition the evidence. Fair enough. I mean, if the petitions committee deem it's required or not, but the thing is, if you get your petition debated, then they might want to look into it themselves, but they're completely controlling the proceedings then. The thing is, right, how are you going to convince the public to get 100,000 signatures if you haven't got the evidence to prove that the chemical factory is polluting everyone? This is the thing. You can't, right? So, you might want to bring a civil case against the chemical factory and then use a civil court, which then you can use the powers. But if you're not just suing a chemical factory, what happens what happens if you're wanting to ban chemical factories and make those chemical productions illegal? The court can't make if you make it unlawful for the whole country or whatever, there are different ways of going about doing stuff, but you still got to prove it. To prove the case. This is the thing. But just like, with like more abstract things like, information's in private companies, I just want to stick with this publishing bit because this is it mainly concerns at the moment. The main problems are like social media, Facebook, YouTube, Facebook and YouTube and Twitter. Really, this is the main thing because they're declared. They're not only declared it for use in connection with running petitions. They're not only given a direction from the petitions committee. The direction, if they're actually, you're not actually asking them to make a direction or to give an order because they've already published that order and direction, right? They've already published it. Now, if you said to them, would it be, what do you think to, could we go share these on Facebook and YouTube, Please can you tell Facebook and YouTube to start letting them as put petitions on there? But they've already done it. They've already issued it. It's here. It tells you, share these petitions on Facebook, email and Twitter. But the thing is, they're private websites, right? Now, they might say, well, we don't say YouTube, right? But if the powers of Parliament standing orders are published, which they are, and published giving directions to you, and those directions have to be enforceable, they're enforceable through standing orders of Parliament, and it's clearly stated that standing orders of Parliament are for required publications to exercise function in Class F. It's already Facebook, email and Twitter, right? You've already got the power on those websites because they've already issued that is the order. Now, what about YouTube? Well, YouTube's argument is not that Parliament haven't issued them about their particular website. They're just trying to say that even if they did, they can't because those powers don't even exist for this type of thing, and they can do what they want, which clearly not, because otherwise it wouldn't be on Facebook, email and Twitter either, would it? You wouldn't be able to exercise that power. And the only reason the Standing Order 145A, you would have to seek them to, a letter from Parliament committee to compel, is because the thing is, you've already got the power anyway yourself through the right to petition and the committee as well. Right? Now, it's Standing Order 145A3, which, that is like, really telling them, there's a legal requirement to comply. But there's already a legal requirement to comply because what that does is confirm that you need that information, and it can be it is something, it is written, it's relevant to what you're doing. So Paul Groves, legal director of YouTube, I'm starting to lose my patience with him for my channel unless someone's hacking it in between, right? And also, they've got different departments in YouTube. They've got copyright department, then they've got like the branding and logo rights department, and then they've got strikes and community. All those are legal fractions of YouTube. But Paul Groves is the overall director. If I want to, mention YouTube in a petition, I've got the right to do that because it's a casework to government, right? Now, YouTube have got a branding application department that deals with using the branding like I have. In fact, I'm using it to what I'm saying now, everything that I've said in this entire recording is I've put it all into a audio recording to kind of like, express the law. Although I didn't actually have this 145A standing orders part of it in, which completely makes sense now. And it doesn't make sense. It's correct. But the ironic thing is, they're already giving the directions and they're already legally enforceable. And they're already made by jurisdiction of the Petitions Committee. But the Petitions Committee don't even seem to understand that, what it's doing. I don't know who works in that committee. It's like Tweedledee and Tweedledum. If you live in London and you're the Spectator or something, or, some extremely affluent graduate, from Eton or something, but not Boris Johnson, I don't know, you end up working in media, or I don't know what you end up doing. Do a degree in politics. God knows where these people in Parliament, how they end up there. Some people end up, cleaning Parliament because they're a cleaner. They just work cleaning offices. I don't know how you get the job cleaning the offices in Parliament, but someone ends up, in the Petitions Committee, working there, assisting, responding to emails because the 11 ministers are busy, unless only they work in the committee. But, Sean Harris is not an elected MP. He's an assistant when he was, right? I don't know what education they've got. I don't know what qualifications they've got. I don't know what university they went to. I don't know what they've been told by MPs. I don't know what they've been told by the Ministry of Justice, right? But if you work in the Parliament Petitions Committee, I don't care who you're taking orders from, Rishi Sunak, the leader of the House of Commons, the leader of the House of Lords, whether it's the leader of the Conservative Party, or whether it's just Scott Benton, or Martin Day MP, or the chairman of the committee, or whether, if you don't know and fully understand with absolute clarity what you are even doing when you're doing it, then you're a retard and you're not fit to be in that committee or working for it on behalf of the public. If you do not know that you have a website on a server that is a digital device and itself is publishing an advertisement and making it available to the public or a section of the public, and that Petitions Committee website is itself a Class F advertisement, and he's giving you directions using Powers 145A to compel and facilitate the sharing of the petitions it's publishing itself to other websites that also use that power, because it's exercising a function and it uses the right to petition to enforce that. And you don't need to ask them to make another order because it's already been made, and they've already exercised that power by publishing it on their own website and writing directions, which everyone has to comply with who engages with that. Then you are not fit to work in the Parliament of England and Great Britain and Wales. You're not fit or capable, and you don't even know what you're doing when you're doing it. You know, like picking up a pen. I'm drawing like a stick man. You know, is that representation? You know, what are you doing even when you're drawing a stick man? So is it a word, a letter, a model, sign, placard, board, or making a representation, or playing hangman? You know, fill the words in, guess the letters, right? Now, is it for a petition though? You know, I'm drawing a picture of, it's like a Conservative advert. I'm drawing a picture of, Alex Salmond with Ed Miliband stuffed in his top pocket. It's a sketch. It says vote Conservative. It's a representation. Now I'm doing the similar one. Oh, I like this Tory advert. I might use that for my petition. Sign my petition. Let's have Alex Salmond with Ed Miliband in his pocket. Instead of vote Conservative with an X, he says, sign my petition 14365A with an X. Right? What am I doing? What is that even? Where's it going to end up? Right? What powers is it using, if any? I'm not selling chips. Now, I need access to my YouTube channel videos, because they are evidence in my petition for me and for the public. And it's for an inquiry into criminal investigation. Now, even if they don't put the channel back online for everyone, I still need access to it myself. Right? And also, for example, I'm wanting to make a claim to the to the civil court against Camelot. And I've got a video on there that I need for that as well, that I uploaded that's on that channel. Because it's evidence that I scratched the scratch card off and won the jackpot, which I need for civil court. Now, we can go about this any way you want, but if Parliament's Petition Committee do not write email to YouTube to restore my channel, which I have stated which channel it is and what email it is, right? Then I'm going to do the exact same thing. I'm going to have to go to the civil court and I'm going to ask for access to the video of me winning the scratch card on my YouTube channel and get a court subpoena. And if Paul Groves does not restore access to my channel to get that video, then he's going to be in contempt of court. Right? Yeah, I'm doing the exact same thing when I am running my petitions case with the Petitions Committee, which there are no standing orders to say how long your petition runs for. It says 6 months, right? And you might say, well, that's published on the website, but there's actually no law for how long a petition runs for, because Laura's tampon tax petition ran for 8 months. It's only on the website. It says it's published on the website, run for 6 months, the digital one. It doesn't mean to say that you can't appeal the case or reopen the case. And in fact, you could probably continue it on paper once you've got a case number and a registered case that matters, you can continue on paper. This is the thing, you know. Or start a new case. But why would you start a new case if you've already got a case number and it's for the same case? You know, what if you're collecting your signatures, you know, this is the thing. You can't collect the signature. You can't collect the 100,000 signatures if you can't promote the petition or publish it. Now, as far as I'm concerned now, the law applies to private platforms. So YouTube can't say that the law doesn't apply to those platforms, and it can't say that, you know, you can't do petitioning on there because people have got their petitions on there, and that's what the law applies to. Now, if they want to say that, you know, they've only issued standing orders that apply on Facebook, email, and Twitter, fair enough. But I'll ask for it for YouTube as well, which I can, because if you can have it for Facebook, email, and Twitter, well, Outlook or Gmail or whatever, it doesn't say which email. Outlook, you know how many different email? You see, it says email, right? Email. Which email? What company? It says use email, right? Which email? Which company are we talking about? Are we talking about Yahoo? Is that covered by Standing Order 145A and Class F and the 2007 instruments? Yahoo? Microsoft? @me.com? Outlook? Hotmail? Gmail? Google Mail? You know, BTnet. Tell me which email that this applies to. He says email, all of them, all of them, all of them, all email. Does it apply to Royal Mail as well in the post? Can I send a letter? Or can Royal Mail say, oh, we're not delivering it? You know, return it, well, I paid the money for it. It's free post to the Royal Mail Assessment Committee, free post. Oh, why they refuse to deliver that? Well, you got a right to complain, you know. Email, which email? So, if they can write the word email and it's all of them, how can it be Facebook and Twitter, which are digital social media platforms, but it not be all of them? How can it? You know, if they offer, and the thing is, I was on there anyway. I won't mind. But if they said, oh, we don't know, there are any petitions on here, none. No petitions. None. Then, but they've got other people on there. They've got other people doing campaigns on there. So that means you can do campaigns on there. Now, when you're doing those, you're using special law that goes with it wherever you use it, or else you can't do it. It's like the court. Wherever you're doing things for the court, you've got powers that go with them. This is the problem. I can't see how they can write email there and it not be all of them. It has to be. So it's impossible, therefore, for them to have Facebook and Twitter and it not mean all of them, or whoever's offering accounts. Now, the thing is, you know, if you had an account and, you know, what was, they clearly, I've had a channel on YouTube for 10 years. They didn't have a problem with it. There was no problem. So what's the problem? You know? And I actually made an error, an upload error, a mistake. And I don't even think there's anything wrong with the channel anyway, because, you know, if there was something wrong with it, they would have found that out 10 years ago. It don't make, it's been, someone's messing around with the channels and then they're messing with us. They're messing around with us. They're triggering things to happen. You know, I went outside yesterday after we went to the post box the other day, and there's that stupid silver Reps car there with Ben on the license plate when I'm going posting Bencop.biz stuff, right? Obstructing the post box, we had to get out. Then I come out the door and there's a black bench tag on the floor and some strange guy parked with a car opposite up the road looking over suspicious, parked up. And then when there was some really weird stuff going on when I went down to the supermarket, this woman waltzing around with locks and chains and keys. And when I wanted to go where I wanted to go, they'd redone the gym and turned it into this storage place. But it was all, they got this barrier around it all. And the exact time when I went to walk through it to get to the supermarket, there's this strange woman waltzing up and down with keys, locks and keys. And she was unlocking the gate and she let me in when she went in. And then as I was walking through, I realised that, I couldn't get through to the supermarket because she fenced it all off. And then when I turned round, she's locking us back in again. So I had to go, or just you have to let me out. I wanted to go through, but I can't get through now because I didn't know they'd changed it. I ain't been down for a while. It's actually all private. I don't think there's a public right of way because I think they only made that footpath for Morrison's. I don't think they bothered putting public right of way on, but you can apply for it. You can apply for public right of way if you wanted to council. But I think they were going to make a law to stop applying for them. But I think one of the ministers tried to stop them taking his right to apply away. But that was odd. Because this particular woman, she wasn't, there's a lot of workmen there, and to be honest, she looked like a Crown prosecutor, that woman, and she looked quite stressed out and straw. Anyway, I'm like, I mean, that might just be total coincidence, but, after that incident, with the post box the other day, I'm like, what's this guy doing parked directly opposite the post box when we're going, and he's got a license plate, Ben. She says exactly like when I saw that guy who looked like Bez when I'm walking up the road, and that guy looks like Bez. And then a car pulled up with a license plate Bez on, and I'm like, bloody hell, that's odd, He looks like Bez, and the car's just pulled up and he just got in, and the license plate says Bez. But I'm not going to be able to run up to him and ask him because by the time I Bez up to him, he'll have driven off. But they drove past me. It was just like waiting at the side of the road. It's like weird. What the hell's going on? Someone's taking the mick. That was probably during lockdown. I might have been a little bit before. I can't remember. But anyway, the petitions committee are refusing. They're obstructing us, but they're already publishing, giving directions, and what they're doing is you don't even need to ask for a unique or special direction. It's kind of like going to court. Can you imagine if court said that, all persons must comply with, 7-8B. Every person must comply with it, right? It was already written, right? Can you imagine then if someone didn't comply with it and you had to go to court to get them to comply with it? But that's what the court have already said, everyone's got to comply with that. Or the government said, everyone's got to comply with that, right? Not like, if you want to access some private information, you've got to tell the court who it is and what information it is, and also tell they're not complying. I need you to compel them to comply. Then that's why they produce the letter to say comply. But when it's specific things that are already declared, like it says here, Facebook, email, and Twitter. They're already being written to. They're being given notice. Facebook, email, and Twitter. So Outlook, Yahoo, you name it, BTnet, whatever, Sky.net, whatever your email is, they're already being, all the email companies are being given directions to comply with the this. And the problem is, why would they not? Because there are loads of people on there anyway doing certain things. Now the thing is, if you've got an issue with some of your content, but what is the issue? I've had issues and then they've, there was no issue, and they just wouldn't. I had to complain multiple times through Twitter to YouTube team to get them to look at it properly, and then they